5 seconds to go. Start. Since the issues raised in all the captioned appeals are same, the parties are also same, and the challenge is also to the self same judgment and order passed by the High Court, those were taken up for hearing analogously and are being disposed of by this common judgment and order. These appeals arise from the judgment and order passed by the High Court of Punjab and Haryana at Chandigarh dated 9 September 2022 in Civil Revision number 6706 of 2019, Civil Revision number 6952 of 2019, Civil Revision number 6980 of 2019 and Civil Revision number 7053 of 2019 respectively, by which the High Court rejected all the 4 revision applications filed by the original defendants by a common order and thereby affirmed the order passed by the executing court permitting the original plaintiff to deposit the balance sale consideration and rejecting the application filed by the defendants judgment debtors under section 28 of the Specific Relief Act 1963 foreshortened the act for rescission of contract. The facts of this litigation giving rise to these appeals as recorded by the High Court in its impugned judgment read thus. 4 connected revision petitions have come up for final disposal. The learned counsel representing the parties are ad idem that those 4 revision petitions can conveniently be disposed of by a common order. Some peculiar facts are required to be noticed. As many as 4 different suits for grant of specific performance of the agreement to sell were decreed by the trial court on 16 August 1994. 4 identical conditional decrees for specific performance of the agreement to sell were passed while permitting the decree holder to deposit the balance sale consideration in the court within a period of 20 days, and the defendant was directed to get the sale deed executed in favor of the plaintiffs. However, the judgments and decrees passed by the trial court were reversed on 24th November 1994 by the First Appellate Court, which led to filing of 4 regular second appeals. The High Court allowed 3 regular second appeals on 3rd May 2018, whereas the 4th one was allowed on 24th May 2018. Resultantly, the decrees passed by the trial court were restored. The decree sheets were prepared on 31st May 2018 and a copy thereof was supplied to the plaintiffs. They filed 4 execution petitions on 4 September 2018. On 7 September 2018, applications to deposit the amount were also filed. The judgment debtors also filed an application under section 28 of the Specific Relief Act 1963, hereinafter referred to as the 1963 Act, for rescission of the contract on account of non-payment of the remaining sale consideration. The decree holder, as permitted by the court, deposited the decretal amount in the court on 7 September 2018. Consequently, on 16 August 2019, the executing court has dismissed the application for rescission of the contract. These 4 revision petitions have been filed for setting aside the orders dated 7 September 2018 and 16 August 2019. The High Court proceeded to record the submissions canvassed by the parties as under. On the one hand, the learned counsel representing the judgment debtors contends that as per the trial court's judgment dated 16th August 1994, the amount was required to be deposited within a period of 20 days. Since the decree holders have failed to deposit the amount within the stipulated time, the contract was required to be rescinded. He further contends that the High Court, while allowing the regular second appeals on 3rd May 2018 and 24th May 2018 respectively, restored the judgment and decree passed by the trial court. He submits that at the most, the amount could be deposited within a period of 20 days from 3rd May 2018 and 24th May 2018 respectively. Since the decree holder failed to deposit the amount, therefore the contract should have been ordered to be rescinded. He, in support of his submission, relies upon the judgment passed by the Supreme Court in Prem Jeevan versus K.S. Venkataraman and another 2017-2 Civil Court Cases 1. On the other hand, the learned counsel representing the decree holders submits that the trial court has correctly extended the period and permitted the decree holders to deposit the amount as ordered in the conditional decree. He submits that a decree passed in favor of the decree holder cannot be permitted to be defeated unless the court comes to a conclusion that the decree holder has intentionally failed to honor the conditional decree. The High Court ultimately, while rejecting all the 4 revision petitions, held as under. From a careful examination of the aforesaid judgments, it is apparent that Section 28 of the 1963 Act enables the executing court to extend the period keeping in view of the conduct of the parties. The courts have also recognized that the decree passed by the trial court stands merged with the decree passed by the appellate court. In this case, the High Court did not fix any time period for deposit of the amount. The application for execution was filed within a period of 4 months. Immediately on filing the execution petition, the decree holders have filed an application seeking permission to deposit the remaining amount which has been allowed. Undoubtedly, the judgment debtors have filed the various applications for rescission of the contract before the amount was deposited. However, in the facts of the case, this court does not find that there was any unreasonable delay, particularly when the High Court did not fix any period for deposit of the amount. The argument of learned counsel representing the petitioner that 20 days period as directed by the trial court shall revive is to be examined in the facts of the present case. The decree passed by the trial court stands merged with the judgment and decree passed by the High Court in the regular second appeal. The question is whether the decree holder willfully failed to deposit the amount under the decree, particularly when the High Court did not fix the time for such payment, or there was in fact unreasonable delay on part of the decree holder to deposit the amount. In view of the detailed discussion hereinbefore, the aforesaid question is answered in the negative. Keeping in view the facts of the case, it is not considered appropriate to conclude that the decree holders failed to honor the conditional decree. The trial court has exercised its discretion prudently while extending the time, and this court does not find any reasonable ground to interfere with the order in the exercise of its revisional jurisdiction, which has been passed in accordance with law. Consequently, all the 4 revision petitions are dismissed. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the only question that falls for our consideration whether the High Court committed any error in passing the impugned judgment and order. The original decree in one of the suits reads thus: in view of the foregoing findings on the aforesaid issues, the suit of the plaintiff succeeds and it is hereby decreed with course in his favor for possession by way of specific performance of the agreement dated 5th April 1989 in respect of the suit land mentioned in para number 1 of the plaint and against the defendant. Stop.